Good afternoon. My name is Brenda, and I would like to welcome you to the Sutherland webinar, Commodity Trading and the Clean Power Plan, Opportunities for the Informed, hosted by Sutherland attorneys David McCullough and Joshua Belcher. If you would like to receive CLE credit for this webinar, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. Should you have any questions during the webinar, please submit them via the Ask a Question text box on your viewing console. President Obama recently released an aggressive regulatory scheme to reduce greenhouse gas emissions from fossil-fired electric utility generating units. While imposing regulatory burdens on many in the utility industry, the Clean Power Plan may provide tremendous opportunities for knowledgeable commodity traders to buy, sell, and trade compliance instruments regulated under the plan. Sutherland Asbill Brennan LLP has provided advice to the commodity trading sector for more than 30 years and will bring its knowledge of the market, similarly structured regulatory programs, and the Clean Power Plan to help you position your trading business for the upcoming markets that will develop under this new regulatory scheme. Sutherland will also provide an instruction on how the Clean Power Plan may impact other areas of the commodity trading company's business. That is what we are here to discuss today, and with that, it is my pleasure to turn the call over to David McCullough.
Thank you, and thank you all for joining us today. We had a significant interest in this program, so we're pleased that you're all able to join us today to talk about the Clean Power Plan. For those of you who are not familiar, though from looking at the registration list, I think most of you are aware, Sutherland is a full-service law firm with offices throughout the United States, London, and Geneva. As many of you know, we take particular pride in our commodity and energy trading practice, where we focus on four main areas. 1, regulatory compliance, 2, enforcement, 3, contractual agreements and disputes, and policy as well. Our practice is based not only in Washington, D.C., but also in Houston and New York, as well as leveraging our experienced lawyers throughout the country and throughout Europe as well. Within the space, we have decades of experience with all of the regulators who have oversight over the commodity trading world, particularly the EPA. This is where Joshua and I squarely practice, as well as a team of lawyers in Washington, D.C., that have more of a focus on advising the actual regulated entities under the CPP, those being the stationary source owners and operators. We may rely on those attorneys if there are questions that are more appropriate for them, rather than in the strict commodity trading space. I'd also add that we attempt to leverage, and I think do so very well, our experience in these areas to bring insights into all facets of our energy trading practice, not just the commodity trading world, including project development work, M&A, and structured transactions. On this slide, it just highlights the pride we have in understanding each major regulatory program impacting our clients' business at a significant depth and detail. And we've been recognized in the industry for this level of understanding. The Clean Power Plan, which Joshua will get into in a minute, is one of those programs. This is a program of significant scope and impact, and one that will cut across not just the power generation industry, but also into the coal, natural gas, biomass, wind, solar, and environmental credit markets of all shapes and form. As a result, having an understanding of not just the EPA and power markets is important, but also all other applicable and respective industries and regulatory bodies, we believe is critical to taking advantage of the opportunities under the CPP. So with that, I'm going to turn it over to Joshua to get into the heart of what the CPP is. Thank you.
Great. Thank you, David. So we're going to do a general CPP overview, and I can't promise that we're going to get into too significant a depth in how it applies necessarily to the regulated entities themselves. But we are going to try to give you a basic snapshot, kind of an overview of what the program does and how it's expected to give rise to opportunities for trading. I mean, I think on a very basic level, the EPA has developed a program that applies emission limitations to existing coal-fired and natural gas utility power plants across the U.S. And we'll talk about this in a little bit more detail, but they do this under a couple different proposed plans. The end result is that coal is going to be taking a significant hit in the electricity markets and be significantly impacted. The winners, by contrast, appear to be more efficient gas-fired plants, renewables, and nuclear energy, and so we'll certainly see them coming forward under the CPP as it begins to be rolled out across the country. Why this, in a snapshot, matters to trading companies is obviously there are going to be the impacts, on a large scale to coal, and as I mentioned, you are going to see both the renewables, the gas, and the nuclear become more prominent players. Primarily, though, with respect to the utilities that are going to be regulated, there's just no ifs, ands, or buts about it. They are going to need to obtain and surrender compliance credits in order to comply with the Clean Power Plan. There's just no sort of control technology that can be rolled out on a broad scale that can help them meet the emission limitations that are proposed under the EPA's plan. And so this is going to necessarily create, we expect, a very large market. We expect that this is also going to, by virtue of how the credits are either generated or allocated, provide additional revenue streams for renewables. So we expect to see a lot of projects going out and trying to monetize that stream. The scheme is for trading, as we'll talk about shortly, is fairly wide open. And EPA continues to take comments on how exactly it should be structured. And then finally, it's unclear at this point exactly how the Clean Power Plan is going to be implemented in each and every state, but without a doubt it is likely to impact, or it's going to impact, a lot of the positions that traders have open in existing environmental commodities like RECs and carbon offsets. So as I mentioned, we're going to see a lot of, primarily it's coal that is going to bear the brunt of this, and there's going to be an opportunity for renewables and for gas and for nuclear. Currently, the primary compliance strategy that the states are expected to pursue will involve a significant increase in natural gas fire generation, and just right now it's anticipated that there are about 5 growth regions in the U.S. where we think we'll probably see a lot of natural gas go up. That's in the Mid-Atlantic, Long Island, the Mississippi Delta, Southeast, and in upstate New York, relatively speaking to what they have. Now, that initial boost to natural gas will be replaced with a increasing growth of renewable energies. And we see, as far as growth areas for where renewables are likely to spring up, are in the Great Lakes, the Southern Plains, the Virginia-Carolina region, the Mississippi Basin. There have been a lot of analyses done on what the Clean Power Plan is going to mean for states. I think it's fairly common knowledge that I think Kansas, Missouri, Nebraska, Tennessee, and West Virginia in particular expect to be hard hit. We're seeing Montana, North Dakota, and even Arizona, some areas where they're going to have some difficulty complying. So these are also going to be some of the areas where you're going to see a lot of need for allowances, and these areas are also going to be trying to draft implementation plans under the Clean Power Plan that will allow them to take advantage of as broad a market, as liquid a market as possible, so that they can bring their compliance costs down. We've got a map up here so you can kind of see, relatively speaking, under the final rule where the rate reductions are expected to have the greatest impact. So again, you can kind of see these states that I just mentioned up in the north, where the the reductions may be fewer, but they also have fewer options on how to comply. The basic concept, though, under the Clean Power Plan is that there is a certain degree of flexibility that states have in implementing it. Now, what the federal government has done has proposed two model trading rules that states could adopt in order to implement the Clean Power Plan within the state. One is what's referred to as a mass-based program. One is referred to as a rate-based program, and we'll get to that in a little bit more detail later. They're draft their own plans, and as long as the EPA signs off on it, they can take advantage of a wide variety of tools to achieve compliance with the Clean Power Plan. In the event that the state programs either do not meet EPA's approval, or a state fails to develop its own plan, the EPA has also developed a federal implementation plan that will be imposed as a backstop in any of those states. That's also currently under development at the EPA. We see a lot of opportunities here under the Clean Power Plan for states to use existing programs to achieve compliance. It looks like, with respect to RGGI, that we're looking at a 20 times that size opportunity, and 5 times larger than the entire AB 32 program. So there's a lot here that is a lot of opportunity here that states can take advantage of, and that if they can take existing programs such as AB 32 and RGGI and reconfigure them so that they can be used as compliance tools with the Clean Power Plan, then certainly that will open up quite a bit of opportunity for the trading community, especially if these programs are to be used as compliance instruments or as compliance programs. EPA has certainly encouraged the states to broaden them beyond their borders and to try to make them as liquid as possible. They are encouraging states to make them so that they can link to other states' programs. And so the idea is that states can take these model rules the EPA has provided, and hopefully they can implement certain programs that allow them to link to other states, and that way it broadens the compliance pool from where credits can be taken. So we'd expect probably in the states where we've got RGGI in the Northeast or California, and CARB, in fact, has already said it's taking a look at the Clean Power Plan and how it can use the existing programs to achieve compliance. They're taking a look at that. We expect them to start to broaden those programs so that adjoining neighboring states can also take advantage of those trading programs, which would significantly expand the market and provide a lot more opportunity for trading the compliance instruments. The details from EPA are still to be forthcoming. There are a lot of issues that are going to need to be worked out in the comments going forward. In particular, is an issue with double counting, because the EPA has sort of cryptically indicated that their emissions reduction credits, as they call them, could also be issued at the same time as a standard renewable energy credit, and it's a bit of a mystery exactly how conceptually that's supposed to work, and I think EPA has largely left that up to the states to work through, and so that's potentially problematic, and something certainly that needs to be addressed going forward. So to get back to the rule, though, generally speaking, we're looking at a program that starts going into effect in 2022. The initial compliance period goes from 2022 to 2029, and then after that is the final compliance period. Utilities are going to have to meet compliance in 3-year increments. Currently, as I mentioned before, we're the implementation, the model trading rules, and the federal implementation plan are still in process. The rulemaking procedures are open. States have until September 6th of 2016 to submit their state plan, or they can submit an initial state plan and request an extension to September 6, 2018, which we largely believe is going to be the strategy for most states. So there is a lot of time in here built in for potential comments, for stakeholders to get involved and to comment on both the federal rulemaking processes and the state rulemaking processes to make sure that they create markets that are as liquid as possible and can encompass and allow as many stakeholders to participate as possible. With respect to legal challenges, I mean, for the outstanding rules is January 21 of 2016. So for the model trading rules that EPA has put out in the federal implementation plan, January 21st is the deadline for getting in comments. With respect to legal challenges, so far we've seen 27 states and a total of 28 petitions for judicial review have been filed. Of course, there are a number of petitioners who are involved in each of those petitions, but that's what we're looking at right now. The deadline to petition for judicial review is January 22nd, so that's still that window is still open for additional appeals to be or challenges to be filed. And then I think soup to nuts, the range of time frame that we're looking to have those challenges resolved is anywhere from 2 to 4 years. So all of that remains to be seen. So keeping in mind as the states and the feds move forward, working on these rules, we're going to have these legal challenges rolling in the background. So moving forward, we'll focus a little bit more specifically now on the actual credits and the types that the EPA is proposing and how they're generated. So as I mentioned, there are these two separate conceptual approaches that EPA is taking to the Clean Power Plan framework. They're looking at either imposing a rate-based program or a mass-based program. The mass-based program is easier. That's what we all have come to know and love as cap and trade. Essentially, the EPA sets they set caps on what each state can emit in terms of tons of CO2, and states are provided with allowances that can then be distributed to regulated entities to meet their compliance requirements. It remains to be seen how the states will choose to allocate those allowances, although we do know that the EPA has at least indicated that there should be set-asides for a number of programs. By contrast, there's the rate-based approach, which uses what are called emission rate credits, and so this relates back to the EGUs and their requirements to meet a certain pounds of CO2 per megawatt generated emission rate. To help them make that compliance requirement, EPA has developed this ERC concept, this emission rate credit, which essentially would be generated by renewables or by other EGUs that are emitting below the required emission rate. Those credits would be used by the out-of-compliance facilities to meet their requirement. So it's a little bit strange concept, but basically an ERC represents 1 megawatt hour of zero emissions, and so it just drops into the averaging calculation for the units under the rate-based program. So these are the two programs: the rate-based, the mass-based. Rate-based have ERCs, mass-based have allowances. Right now, there's a broad expectation that the mass-based approach is the approved or the kind of preferred approach, since that's something that I think most folks are familiar with. But again, the jury's still out on that as comments continue to roll in. Note that under neither of the model rules are the concept of offsets considered, so there's no sort of alternative compliance, some alternative offset program, at least as proposed under the federal program. Now that could change, obviously, if the states take the state plan approach and kind of develop their own program. So again, there are going to be opportunities to weigh in as a stakeholder at the state level to see about how those programs can be adjusted to maximize their liquidity and opportunities for participation. Common to the two approaches that EPA has proposed is this Clean Energy Incentive Program, and that's actually a period of time before compliance requirements kick in, where certain projects can receive either ERCs or allowances as sort of an early action incentive. Now the projects, they're strictly limited in that the projects have to commence after submission of the state plan. So essentially it's going to have to be after the 2018 deadline. They can't, projects arising before then can't really be used, but it's meant to incentivize kind of that brief window where additional projects can be brought in to obtain these early action credits. And it's only for generation or savings that occurs in the years 2020 and 2021. After that, they no longer qualify for the early action credits. What makes them valuable, though, is that the states will award them and EPA will provide matching allowances or ERCs. And so there's a little extra piece in there for projects that can actually qualify. During the compliance periods, you're going to see a lot of renewable energy projects become available for credits. They're less restrictive there. They just need to be projects that have started after January 1st, 2013, and there's a very broad range of renewable energy types that can qualify to generate ERCs or obtain allowances. And you can see up there, this is just a few of them. Credit trading, as far as we've seen, has not been restricted at all. Everything that we've seen so far has suggested that the ERCs and allowances can be freely traded and held. What we do know is that they can be banked, and EPA has suggested that they can be banked indefinitely. They have stated that they do not anticipate borrowing from future years to be allowed, although they are taking comments on that. And then generally, they are going to impose on credit trading very strict measurement and verification requirements. And so, those of you who are familiar with, for instance, AB 32 and the invalidation risk associated with compliance instruments under AB 32, that's going to be a risk, especially where the EPA is going to be tasked with making sure that all of these credits represent, actual verifiable ERCs or allowances reductions, ultimately in CO2. But because the model trading program is so wide open at this point, there's a lot of opportunity for traders to get involved. But again, that being said, we're still in the comment stages, and there are a lot of stakeholders who are going to be voicing their opinion here. On the one hand, you have folks who are going to want to restrict this as much as possible and worry about sort of whether the integrity of the market would be challenged by broad participation. But then by the same token, you're going to have a whole group of folks who are going to be very interested in making sure that these markets can sync up, that the compliance programs are compatible, and that they are structured in such a way that allows them to maximize liquidity, which would ultimately bring down, the expectation is it would bring down the compliance costs for well, for the regulated community, but ultimately for energy consumers like us. In developing these state trading programs, again, states are really going to have to think long and hard about how they develop them, because they're going to have to, if they want to take advantage of a broad trading platform, they're going to have to link up. Now, the federal government, the EPA, has given very precise guidance on how they expect these programs to be able to link up, but the states have to follow these guidelines in developing their programs. They've said that only states that are rate-based, only states that are mass-based can trade with other mass-based states. And so that's another consideration that's going to be under heavy scrutiny as states go forth and consider how to implement the Clean Power Plan individually. But as I mentioned, there are a number of ways that states can promote trading, particularly by ensuring that their programs link. But this is all open for comment. This is all still very much at the early development stages, and so the feedback provided on how to develop these programs is actually going to be quite critical. And so with that, Dave, I'll turn it over to you so you can talk a little bit about kind of the broad opportunities here that you've identified.
Great. Thank you, Joshua. As a matter of housekeeping before I get started, for those of you that are dialed in and are looking for CLE credit, the code that you need to submit for your CLE credit is Clean Power Plan. Not very original there, but easy to remember. This first slide covers a lot of what Joshua has talked about a little bit. We talked about the size of the market and how significant it will be. We also wanted just to highlight a couple items that you can do right now and at least start to get in order. The first being your contracts, and start thinking at least about development of GTCs, confirms, master agreements, and what those might start to look like. Obviously, we don't have the details of the plans yet, but those are things that you can conceptually start to think about, as well as monitoring state implementation. And we'll talk about that on the next slide. Joshua, can you forward that? Great. So these are on this slide and the next slide, highlight key takeaways for that we want to leave you with as traders of commodities. The first is that there's a long implementation timeline here. Actual compliance obligations do not begin for impacted EGUs until 2022. But there are, of course, going to be opportunities that arise for renewable energy generation before that time period. The state plans that Joshua discussed are due in 2018. And the takeaway on that point that you should take from this call is that as non-regulated entities, you can take a deep breath and become educated at this time. There's been significant press because of the impacts on state generation load and capacity, but the opportunities for you, at least the significant opportunities, might not arise for a little while. Early engagement is critical if you want to take advantage. At this point, we don't know what each state is going to do in terms of adopting a credit trading plan in the first instance, let alone what type of credit trading program each state will implement. Therefore, we recommend tracking the developments on the state level at a minimum and seeing how that progresses for each state and what the outlook begins to look like. There is you should consider submitting comments or engaging directly with the White House to develop workable credit trading programs. We understand that most commodity trading companies do not like that type of publicity, but of course there are opportunities to work part of a group that may protect a certain amount of anonymity for you. In terms of liquidity, and Joshua touched on this briefly, but we believe it's not likely to see significant market liquidity until at least 2022. The auction/allocation process at the moment is far from less than certain. There will be some early ERCs, but it's anticipated that EGUs will seek to acquire them and hold them as much as possible for compliance reasons. After 2022, renewable projects such as wind and solar will begin rolling off their ERCs into the market. And nonetheless, regarding how EPA disperses these credits into the marketplace, there'll be ways you can take action now. There are existing compliance markets that may become part of the CPP that you can become active. The most notable of which that Joshua highlighted, and I stress this is possible, is the California Cap and Trade Program, which is already a very active market and may become more in demand when the scope of the program increases significantly. So you can begin taking positions in those markets knowing that demand is potentially likely to increase in the future. Similarly, the scope of the markets is likely to dwarf other stationary source programs such as the acid rain program. This will be, at least in my opinion, and I think some of the other attorneys on the call, this is to be much more akin to something like the Federal Renewable Fuel Standard, where you have a federal program that really cuts across an entire swath of a very, very large market and goes to the core of what that market is. And it will certainly create carbon markets on a scale that we have not seen before. Another key element is this potential for a federal trading platform and cross-state trading. We've seen this significantly enable the federal renewable fuel standard markets, the RIN markets, and the CPP now directly and explicitly states for the potential of that type of federal trading platform. We don't know what that will look like, but there certainly is cross-state trading that is enabled. Next point, last point on this slide, is that anyone can trade. That, for you, should pose both opportunities, obviously, and significant risks. This is very different from other stationary source Clean Air Act programs, but is very similar to other existing carbon markets, both at the state level and at the federal RFS level. This is a double-edged sword for many of you. You'll be able to participate despite not having generation facilities or an interest in generation facilities, but there will very well may be very small players out in the market who seek to take positions and benefit from a new market opening up. And whenever you have that type of scenario, and we've seen that before, particularly in mandatory markets, non-voluntary markets, that can make for strange bedfellows. I'm going to advance to the next slide. That raises directly the issue of credit validity. And when you're forced into, or at least have a limited ability to choose your business partners, and might have someone who comes from the power generation side dealing with someone who comes more from a strict commodity trading background, dealing with someone who might come from an agricultural background or an oil market background, there can be a bit of a clash of worlds. Now, that's particularly relevant in the case of credit validity. This is always a concern when dealing with other environmental credits, as Joshua discussed, but I really think particularly when it's a non-voluntary market and one that brings together, as I said, those unnatural business partners of particularly varying credit worthiness. Unfortunately, in what we've seen, EPA doesn't appear to have learned its lesson from the federal RFS program, and just I'll quote briefly from the rulemaking that says, despite safeguards included in the structure of the ERC issuance and tracking system, such as review of eligibility applications and EPA issuance of ERCs may be issued that do not in fact represent eligible zero-emission megawatt hours as required by the plan. A variety of situations may result in such improper ERC issuance, ranging from simple paperwork errors to outright fraud. The EPA requests comments on ways that EPA could safeguard the validity of an ERC. Now, hopefully many of you, that rings a lot of bells for you and have ideas on ways that you could help to ensure validity of those credits, whether it's development of an auditing process, EPA standing by the issuance of ERCs or allowances. But if that doesn't scare you in terms of having that possibility for invalidity and having the validity being required to be imposed and the responsibility for that validity on the holder of the particular credit, then you haven't been involved much in the environmental credit markets. You'll want to bake that credit validity directly into your business dealings and contracts, both in terms of diligence and documentation. Documentation is key from our experience because while you can certainly do your due diligence, it's hard to go out to every single project that might be generating a credit, and it's particularly hard to validate something that is intangible in one respect and maybe slightly tangible in others, but at the very least, very difficult to quantify and easy to forge. A range of other documentation issues that you'll want to take into account, and not just credit validity, is also in terms of that double counting and just generally, as I said, a lot of the credit aspects of your documentation will want to be reviewed. In the early days of the RIN markets, we saw companies that simply scratched out gasoline and put in RINs because they were so eager to trade RINs and were sort of shocked by this market that opened up despite having legislation that was passed several years before. You don't want to be in that position. You don't want your traders to be in that position. It's best to have at least some general forms prepared that they can hit the ground running with. And you can always work with industry. As you know, hopefully know, there are a range of organizations out there that develop standard documentation, and you can start reviewing and working with those organizations. Lastly, we want to highlight a few specific opportunities for particular types of commodities. One is this displacement of coal and natural gas. Demand will certainly decrease for coal in the covered states from 36% in what would otherwise be in 2030 without the CPP to 28% in 2030 with the CPP, according to EPA's own numbers. The interesting part is that Puerto Rico, Guam, other territories, as well are directly not covered by the CPP. And right now, Alaska and Hawaii are not either, subject to additional information EPA receives. They said they're still analyzing that issue. Now, that may cause displacement of coal to those territories and to those states. So you could see opportunities to line up supply deals in those territories as well as those states. You could also see demand increase in Canada for otherwise displaced coal or natural gas, just simply because of the CPP. Obviously, Canada is taking its own measures that would have an impact as well. But the Canadian aspect is particularly interesting because imports of electricity are not covered by the CPP, meaning you could have the same type of generation going on in Canada and bring that electricity into the U.S. That's been highlighted in a few articles out there, so there are people thinking about that. We already are a net importer of electricity. Obviously, particularly on the northern border, and particularly in some states. You saw that Vermont is not covered by the plan. It's because they don't have any covered EGUs. They import a significant amount of their electricity from Hydro-Quebec. You could see similar situations arising in other states as well. And as a result, not only you have that electricity imports, but you have Canadian generation that could be advantaged simply because of the CPP. But again, obviously there are other factors that go into see whether they are actually advantaged. We also noted that biomass might get some advantage here than it otherwise would have. Biomass is at least one commodity that came to our mind that is combusted but is not covered by the CPP, in that there are electricity generating plants that combust biomass, and particularly in the north. These are wood pellets and other wood scraps used to generate electricity. This is a relatively cheap way of generating electricity, at least compared to other types of renewables. And again, it's the type of generation that actually has emissions but is not going to be covered by the CPP. In addition, you might get credits under the CPP for biomass. That's subject to comment at this time. So that's both the underlying biomass and the assets are something that you could see get a boost where, particularly in areas that are otherwise facing a decline in their generation particularly from coal. We saw that in the slide earlier where Joshua had and highlighted that the northern tier states are particularly hit. While biogas does not, from our vantage point, and the reason for that, and biogas, for those of you who are on the call that are not familiar, is gas that's collected from landfills, dairy farms, other waste sources that may seem rather esoteric, but is actually becoming a much more prominent type of gas, particularly a way to generate credits in various markets, and has become very popular as of late. It's never going to be a huge portion of our generation in the country, but it still does provide for some opportunity. Now, why it's disadvantaged under the program, at least as an initial matter, is that power plants that might be burning biogas do not get any special treatment. And traditionally, most of the biogas sourced in the U.S. was burned and combusted in power generation facilities. That is moving away right now to generating RINs under the federal RFS. And that's when you're using the electricity as a transportation fuel, using it in the using the biogas in the transportation as a transportation fuel in a transportation vehicle. So there would not be under the CPP any advantage for a stationary source to source its biogas and combust the biogas there, at least at the outset. It may be that they do get ERCs, it may get ERCs, but again, that's subject to comment. And instead, we think it's much more likely that biogas will continue to flow as a transportation fuel due to the significant incentives provided under the federal RFS. So with that, that concludes our presentation for this afternoon. We do appreciate you participating. We've received a few comments or a few questions. I just want to review them very briefly, and we can throw a couple out, and Joshua and I can answer. We also, of course, have our contact information on this slide deck, and you're always welcome to reach out to us. And if we don't get to your question here, we will respond separately. So Joshua, as I look through these questions, I'll pose the first question for you. Would a project that uses CO2 for oil field purposes but recirculates and reuses the CO2 quality be eligible for ERCs or allowances?
Well, no, I'm going to say no, I don't believe so. I mean, the way that they're going to allocate ERCs and allowances are very specific. ERCs would go to, as I mentioned, either a renewables project, a demand-side efficiency, that sort of program, or if you have a covered entity that is beating its required emissions rate. And so those are only going to be the coal-fired and the natural gas-fired power plants that are subject to the rule. With respect to allowances, currently there is no firm requirement on how those are allocated. So, presumably it may be possible that a state in developing its program might say it's willing to allocate some allowances for a project like that, but that remains to be seen. There's nothing on the books under the federal proposals at this point that would suggest that that's a possibility. But I believe we have, as you mentioned, we've got some of our folks on the line who are more intensely experienced in the Clean Air Act side and advising actively the regulated entities and who've been following this rule as well. If we've got Emily on the line, either back me up on that, Emily, or challenge my response.
And I would add,
I'd
add that Emily is one of our colleagues in our Washington, D.C. office that I referenced at the beginning of the presentation.
Yes, hello. Yeah, I think, Joshua, what you said is right on point. All I would add is that, EPA is accepting comment on the federal rule and the proposed model state rules on what type of resources are eligible to earn ERCs and allowances. So if these are, methods that people are interested in, it's certainly a topic that is available for comment. There's no guarantee as to what EPA will do, of course, but it's certainly something that could be provided in the comments that are due January 21st of next year. And I think, as you said also, Joshua, it's something that could be brought to states because the state plans will ultimately determine what sources are eligible to earn ERCs and allowances. So if it is an approved project in a state plan, keeping in mind that EPA has to approve the state plans, but if it is included in a state plan, then it would be eligible to earn them. But as you said, there's nothing on the books right now that points towards EPA considering that.
I have another question, and this is, are buyers allowed to hoard allowances for their own purposes, even if they have no use for them or intention to retire them? And I can address that. Under the current draft of the rules and the trading programs, parties are allowed to hold allowances, and they indefinitely at this point. However, there's a point on the slides that I failed to cover, and this is the bullet on the last slide, that don't live in a bubble. The CFTC, FTC is watching. These are agencies outside of the Environmental Protection Agency. The CFTC is probably most well known for implementing the financial reforms, Dodd-Frank, as of late. But CFTC has at various points explored having jurisdiction over the environmental credit markets, and as well as the underlying commodities that they certainly believe that they do have jurisdiction over. And market manipulating activity is certainly one that you would want to be concerned about, just like when you're trading any type of commodity. So if you have a legitimate business reason for your trading position, then that's perfectly acceptable. But if there is an intent to manipulate the market in any way, that's why when you're looking at these markets, you want to be sure to take your existing compliance plans and ensure that it covers environmental commodities. It's an area that companies have at times overlooked in their compliance manuals. They have detailed instructions for the positions they're going to take in the electricity markets, that they're going to take in the natural gas markets, but they overlook the environmental credit markets, and for good reason, because it's always been a bit of a nascent market, but it's rapidly exploding and expanding in the case of RINs, and then we saw with California Cap and Trade, and now with the CPP, it's going to be a very robust market. So short answer is not directly, but indirectly, and that's why you can never think of one of these regulatory programs in isolation on its own. We have a couple more questions, but I think some of those will be best taken offline, and we'll respond to them individually. But we very much appreciate all of you participating, and I will turn it back over to the operator to close out the presentation. Thank you.